Thank you.
Thank you, counsel. Ferris.
Mr. Chief Justice, and may it please the court. This country's 21 million government employees should have the right to talk publicly about their jobs on personal social media accounts like their private sector counterparts. As this court addresses the question presented, this court should adopt the Sixth Circuit's duty and authority or state official test because it complies with this court's precedent and requires that a government employee is either exercising power possessed by virtue of state law or made possible only because he is clothed with the authority of state law. Petitioner wrongly advocates for an inherently subjective test that divorces the state action inquiry from state law. Petitioner's test will result in uncertainty and self-censorship for this country's government employees, despite this court repeatedly finding that government employees do not lose their rights merely by virtue of public employment. James Freed's Facebook account is the perfect example of the danger of petitioner's test. Mr. Freed opened a personal Facebook account in 2008 as a college student at Indiana Wesleyan University. For 12 years, he built up the account to interact with friends, family members, and colleagues to talk about his passions and interests, including his wife, daughter, his dog, his work, and his favorite Bible passages. As he had done for over a decade while operating the account, in 2020, Mr. Freed made a private choice, like any other Facebook user could do, to block petitioner and delete petitioner's comments from the page. After being sued, Mr. Freed deactivated the page and stopped speaking to his family and friends and the public on Facebook because he did not want to lose control over his own speech by the threat of state action. Such self-censorship for government employees will not only have a negative impact on government employees themselves, but as society, in addition to society as a whole, as the voices that may advance knowledge and the search for the truth will be silenced. I welcome the court's questions.
There's quite a bit on the site about personal activities, including the battles with raccoons and other things. But petitioner says that the balance changes somewhat during COVID, during the COVID crisis. Would you react to that and whether or not that sort of episode is enough to convert this into official activity on this site as opposed to a personal site?
Yes, Justice Thomas. So when you look at from the joint appendix from 15 to 24, you can see that from the time that COVID started in March of 2020 through the day that the post in which petitioner claims he was then blocked and deleted, Mr. Freed only makes 14 posts. And just to give some context to that, from March 2019 to May of 2020, he made 451 posts. He was very clearly a very active Facebook user. And in those 14 posts—
Before you go on, just the COVID activity, though, is that, would you consider that government speech?
No, Your Honor, and he had no duty or authority to be the COVID spokesperson from the county. And when you really look at those 14 posts, all he was doing was resharing information from other sources. And most often, in only 2 instances, was it the city of Port Huron. There were other nonprofit entities, there was other government agencies that weren't the city of Port Huron. He was sharing information just like your neighbor might have done on Facebook, like anyone else during COVID. So nothing changed during that COVID time period.